Section 5 Legitime Article 886. Legitime is that part of the testator's property which he cannot dispose of because the law has reserved it for certain heirs who are, therefore, called compulsory heirs. Article 887. The following are compulsory heirs: 1. Legitimate children and descendants, with respect to their legitimate parents and ascendants. 2. In default of the foregoing, legitimate parents and ascendants, with respect to their legitimate children and descendants. 3. The widow or widower. 4. Acknowledged natural children, and natural children by legal fiction. 5. Other illegitimate children referred to in Article 287. Compulsory heirs mentioned in NOS 3, 4, and 5 are not excluded by those in NOS 1 and 2, neither do they exclude one another. In all cases of illegitimate children, their filiation must be duly proved. The father or mother of illegitimate children of the three classes mentioned, shall inherit from them in the manner and to the extent established by this Code. Article 888. The legitime of legitimate children and descendants consists of 1/2 of the hereditary estate of the father and of the mother. The latter may freely dispose of the remaining half, subject to the rights of illegitimate children and of the surviving spouse as hereinafter provided. Article 889. The legitime of legitimate parents or ascendants consists of 1/2 of the hereditary estates of their children and descendants. The children or descendants may freely dispose of the other half, subject to the rights of illegitimate children and of the surviving spouse as hereinafter provided. Article 890. The legitime reserved for the legitimate parents shall be divided between them equally. If one of the parents should have died, the whole shall pass to the survivor. If the testator leaves neither father nor mother, but is survived by ascendants of equal degree of the paternal and maternal lines, the legitime shall be divided equally between both lines. If the ascendants should be of different degrees, it shall pertain entirely to the ones nearest in degree of either line. Article 891. The ascendant who inherits from his descendant any property which the latter may have acquired by gratuitous title from another ascendant, or a brother or sister, is obliged to reserve such property as he may have acquired by operation of law for the benefit of relatives who are within the third degree and who belong to the line from which said property came. Article 892. If only one legitimate child or descendant of the deceased survives, the widow or widower shall be entitled to 1/4 of the hereditary estate. In case of a legal separation, the surviving spouse may inherit if it was the deceased who had given cause for the same. If there are 2 or more legitimate children or descendants, the surviving spouse shall be entitled to a portion equal to the legitime of each of the legitimate children or descendants. In both cases, the legitime of the surviving spouse shall be taken from the portion that can be freely disposed of by the testator. Article 893. If the testator leaves no legitimate descendants, but leaves legitimate ascendants, the surviving spouse shall have a right to 1/4 of the hereditary estate. This fourth shall be taken from the free portion of the estate. Article 894. If the testator leaves illegitimate children, the surviving spouse shall be entitled to 1/3 of the hereditary estate of the deceased and the illegitimate children to another third. The remaining third shall be at the free disposal of the testator. Article 895. The legitime of each of the acknowledged natural children and each of the natural children by legal fiction shall consist of 1/2 of the legitime of each of the legitimate children or descendants. The legitime of an illegitimate child who is neither an acknowledged natural, nor a natural child by legal fiction, shall be equal in every case to 4/5 of the legitime of an acknowledged natural child. The legitime of the illegitimate children shall be taken from the portion of the estate at the free disposal of the testator, provided that in no case shall the total legitime of such illegitimate children exceed that free portion, and that the legitime of the surviving spouse must first be fully satisfied. Article 896. Illegitimate children who may survive with legitimate parents or ascendants of the deceased shall be entitled to 1/4 of the hereditary estate to be taken from the portion at the free disposal of the testator. Article 897. When the widow or widower survives with legitimate children or descendants, and acknowledged natural children, or natural children by legal fiction, such surviving spouse shall be entitled to a portion equal to the legitime of each of the legitimate children, which must be taken from that part of the estate which the testator can freely dispose of. Article 898. If the widow or widower survives with legitimate children or descendants, and with illegitimate children other than acknowledged natural, or natural children by legal fiction, the share of the surviving spouse shall be the same as that provided in the preceding article. Article 899. When the widow or widower survives with legitimate parents or ascendants and with illegitimate children, such surviving spouse shall be entitled to 1/8 of the hereditary estate of the deceased, which must be taken from the free portion, and the illegitimate children shall be entitled to 1/4 of the estate, which shall be taken also from the disposable portion. The testator may freely dispose of the remaining 1/8 of the estate. Article 900. If the only survivor is the widow or widower, she or he shall be entitled to 1/2 of the hereditary estate of the deceased spouse, and the testator may freely dispose of the other half. If the marriage between the surviving spouse and the testator was solemnized in articulo mortis, and the testator died within 3 months from the time of the marriage, the legitime of the surviving spouse as the sole heir shall be 1/3 of the hereditary estate, except when they have been living as husband and wife for more than 5 years. In the latter case, the legitime of the surviving spouse shall be that specified in the preceding paragraph. Article 901. When the testator dies leaving illegitimate children and no other compulsory heirs, such illegitimate children shall have a right to 1/2 of the hereditary estate of the deceased. The other half shall be at the free disposal of the testator. Article 902. The rights of illegitimate children set forth in the preceding articles are transmitted upon their death to their descendants, whether legitimate or illegitimate. Article 903. The legitime of the parents who have an illegitimate child, when such child leaves neither legitimate descendants, nor a surviving spouse, nor illegitimate children, is 1/2 of the hereditary estate of such illegitimate child. If only legitimate or illegitimate children are left, the parents are not entitled to any legitime whatsoever. If only the widow or widower survives with parents of the illegitimate child, the legitime of the parents is 1/4 of the hereditary estate of the child, and that of the surviving spouse also 1/4 of the estate. Article 904. The testator cannot deprive his compulsory heirs of their legitime, except in cases expressly specified by law. Neither can he impose upon the same any burden, encumbrance, condition, or substitution of any kind whatsoever. Article 905. Every renunciation or compromise as regards a future legitime between the person owing it and his compulsory heirs is void, and the latter may claim the same upon the death of the former, but they must bring to collation whatever they may have received by virtue of the renunciation or compromise. Article 906. Any compulsory heir to whom the testator has left by any title less than the legitime belonging to him may demand that the same be fully satisfied. Article 907. Testamentary dispositions that impair or diminish the legitime of the compulsory heirs shall be reduced on petition of the same, insofar as they may be inofficious or excessive. Article 908. To determine the legitime, the value of the property left at the death of the testator shall be considered, deducting all debts and charges, which shall not include those imposed in the will. To the net value of the hereditary estate, shall be added the value of all donations by the testator that are subject to collation, at the time he made them. Article 909. Donations given to children shall be charged to their legitime. Donations made to strangers shall be charged to that part of the estate of which the testator could have disposed by his last will. Insofar as they may be inofficious or may exceed the disposable portion, they shall be reduced according to the rules established by this code. Article 910. Donations which an illegitimate child may have received during the lifetime of his father or mother, shall be charged to his legitime. Should they exceed the portion that can be freely disposed of, they shall be reduced in the manner prescribed by this code. Article 911. After the legitime has been determined in accordance with the 3 preceding articles, the reduction shall be made as follows. 1. Donations shall be respected as long as the legitime can be covered, reducing or annulling, if necessary, the devises or legacies made in the will. 2. The reduction of the devises or legacies shall be pro rata, without any distinction whatever. If the testator has directed that a certain devise or legacy be paid in preference to others, it shall not suffer any reduction until the latter have been applied in full to the payment of the legitime. 3. If the devise or legacy consists of a usufruct or life annuity, whose value may be considered greater than that of the disposable portion, the compulsory heirs may choose between complying with the testamentary provision and delivering to the devisee or legatee the part of the inheritance of which the testator could freely dispose. Article 912. If the devise subject to reduction should consist of real property, which cannot be conveniently divided, it shall go to the devisee if the reduction does not absorb 1/2 of its value, and in a contrary case, to the compulsory heirs, but the former and the latter shall reimburse each other in cash for what respectively belongs to them. The devisee who is entitled to a legitime may retain the entire property, provided its value does not exceed that of the disposable portion and of the share pertaining to him as legitime. Article 913. If the heirs or devises do not choose to avail themselves of the right granted by the preceding article, any heir or devisee who did not have such right may exercise it. Should the latter not make use of it, the property shall be sold at public auction at the instance of any one of the interested parties. Article 914. The testator may devise and bequeath the free portion as he may deem fit.